and good afternoon, everyone. And thank you for coming. It's a tough choice between a lecture in the afternoon and the beach here in Barcelona, so I consider it to be a compliment. Thank you very much. So Judith has already introduced me. I approach translation from three different perspectives: from the perspective of a teacher at the university, from the perspective of researcher, and from the perspective of practicing translator and interpreter. And I think these different perspectives are very useful for me and students because it's trilateral, basically, communication and exchange, and each perspective informs the other. Okay. Even though today's lecture that I was asked to present is primarily based on something that might be called a language for specific purposes studies, like legal translation, legal English studies, I will also briefly touch upon the aspect of translation itself. Okay, and of course, if you have more questions about the translation aspect, perhaps we can discuss that after the lecture. But before I continue, I would also like to express my appreciation to both Professor Judith Freixa and the University Pompeu Fabra for the kind invitation to take part in this series, and also for supporting my stay here in Barcelona and for opening the opportunity to be here. Okay, so this is more or less the structure of the lecture for today. Bear in mind that legal metaphors is a rather narrow niche of research. I would like to dedicate first half of this lecture on discussing how the law speaks in metaphors. So why are legal metaphors important both for legal professionals and language professionals, of course. Then I would briefly like to discuss some of the methodological approaches to translation of metaphors and to the study of metaphors in general. And finally, in the second half of my presentation today, I will present the results of a study I conducted on the use of legal metaphors in the judgments of the Court of Justice of the European Union, with some possible ESP implications. ESP stands for English for Specific Purposes. So basically teaching legal English, right? Implications. So this will be more or less the structure of my lecture. But before we actually, begin, I would like to start with a recent case that was delivered before the European Court of Justice. It's the case of Miss Pindamulla versus Spain, and it was delivered last September, if I'm not mistaken. It's a case that was delivered by the Grand Chamber. So this is, as you know, the Grand Chamber deliberates on cases which are of utmost importance for the EU, and a unanimous ruling was delivered by 70 judges. Just a brief background of this specific case. Ms. Pindamulla was admitted in a hospital. She was supposed to go through a surgery, minimum invasion surgery, but because of her convictions, she did not accept the treatment with blood. She wanted to have a no blood medicine approach. So she wanted to be treated, but with alternative approach, without the administration of the blood. And she made this very clear in official legal documents, powers of attorney, she presented to the hospital staff. However, after the surgery, she found out that the medical staff had actually administered blood without her consent, of course. And of course, she was shocked to find out that. So this was just in a nutshell about the background of the case. The key principle that was addressed in this specific case was that competent adult patients have the right to refuse medical treatment and choose alternative methods. And the core finding was that no doctor may impose treatment on a lucid, competent patient against his or her will. Meaning that, for example, not just when it relates to blood administration, but also, for example, a patient who refuses to use chemotherapy may choose to do so. So doctors cannot impose that if the patient does not wish to use that particular method. And this is a very significant case because it reaffirms patient autonomy and right to determination and rejects something that is called medical paternalism. I had to do a little bit of background info for what we're about to see. we will see just one section from the deliberation before the court. And please notice the argumentation and the reasoning that attorney at law representing Ms. Pirdomulha uses. Sorry.
The duty judge orders or gives carte blanche to doctors to impose any treatment they want on the patient. Ms. Finder has now become an object, a broken object in the doctor's hands to do with her what they wish. So you see, this is how legal paternalism came in support of medical paternalism. Both doctors and judges knew Finder's will, but they treated her like an object. Madam President, honorable judges, you now have the opportunity to confirm your case law for the sake of legal certainty. No doctors can be allowed to force an unwanted treatment on a patient who has clearly expressed his or her will orally or in writing through advanced medical directive. Please, no more medical rape authorized by courts. I believe this is enough for you to conclude the violations of Articles 8 and 9 of the Convention.
Okay, now this is just one segment of the reasoning used by the attorney at law. So I suppose you have noticed different metaphors that were employed in the use and in the reasoning. A broken object, medical rape, medical paternalism, and if we were to continue, there were other metaphors as well. But all these metaphors suggest that patient's will was disregarded, patient is not perceived as autonomous person, patient was not even a party, so the proceedings were ex parte, so patient was stripped of any legal agency. And of course, patient's right to self-determination was disregarded. So hence the unanimous decision was that there was the violation of Articles 8 and 9. Of course, so this illustrates the use of legal metaphors in a legal context. If we, of course, analyze the literature, and not just strictly speaking specialized domains such as legal literature, but popular media and so on, you can find all sorts of metaphors relating to the legal matters and also diplomatic matters and so on used on a day-to-day basis. You have just some of the examples here. But what this shows is that metaphors are basically an all-pervasive feature of both spoken and, of course, written language. And when it comes to the language of law or legal discourse, Lakoff and Willing have noted wittily that the Supreme Court is a remarkable institution. By a 5-4 vote, it can decide what metaphors we will live or die by. It's time to recognize and speak regularly of the metaphor power of the court, the power to make metaphors legally binding. It is an awesome power. This is something the press should be reporting on, legal theorists should be writing about, and all of us should be discussing. So if some of the students here are looking for a potential niche of research or focus for their research, perhaps you might want to consider also this as a potential. Now, how does the law actually speak in metaphors? Well, first of all, law is, as we know, a major area in which reality is metaphorical because it's an imaginative product of human cognitive capacity, right? And this is obvious in linguistic metaphors, such as this one, the long arm of the law, right? But also, it's present in those less obvious cases, such as in this one, to break the law, where law is perceived as an object that can be broken. Now, of course, the use of legal metaphors in legal discourse is juris generative. Now, what does that mean? It means that metaphors are not used just as a device, a rhetorical device, as a means of persuasion, but they also create legal meaning and concepts. Within the context of metaphors, it's critical to acknowledge also the fundamental concept of frame. In this context, we are talking about judicial frames of reference, which means that depending on the frame chosen by a judge or attorney in law, different balance might even be struck, even in cases which are nearly identical. So depending on which reference frame the judge or attorney chooses. Of course, they influence lawyers' perceptions and validity of arguments in some cases, and metaphors are, of course, based on cognitive structures that serve as internal architecture of the reasoning and conceptualizations. So sometimes it's even possible to analyze the metaphors employed in certain cases to see and reconstruct the legal reasoning in one particular case. Metaphors are, of course, necessarily imperfect by their nature, because they do cover some aspects of the study of the subject matter, but not all aspects, right? This is why some legal theorists very frequently quote Justice Cardozo. This is a well-known quote of Justice Cardozo, who said that the metaphors in law are to be narrowly watched, for though starting as devices to liberate thought, they end up often by enslaving it. And there was a resistance by some theorists when it comes to the use of metaphors in legal discourse, because legal discourse is traditionally considered to be very, or it should be, very precise, very accurate. Sometimes, though, we know that it's intentionally ambiguous, of course. But somehow, under this perception, metaphors were seen as a big no-no in the legal discourse. However, the reality, of course, is something completely different, as we will see in the examples to follow. There haven't been a lot of studies in the field of legal domain when it comes to the use of metaphors. I will present some here just to give you a brief overview. Smith, for example, categorized the use of metaphors in legal discourse into 4 categories. First, metaphors being employed in the judicial principles, and I'll give you some examples of each of these categories. Then metaphors being used in the process of legal reasoning in specific legal issues. Metaphors being applied by legal authors, and metaphors existing in the language. Our language is inherently metaphorical, of course, and not just language. So, of course, they will be used, whether you like it or not. So basically, we can talk about autochthonous and autonomous legal metaphors. Autochthonous are metaphors which were created or used within the specific legal domain, and allochthonous are those metaphors which are imported from other domains. And we will see some of the examples now. When it comes to the first category of legal principles, here are some examples. For example, under the Canadian Constitution, there are 2 opposing metaphors that describe the Constitution in Canada. One is the living tree metaphor, and the other one is the constitutional architecture metaphor. The former presents a rather dynamic interpretation of Canadian Constitution, meaning that it needs to be needs to evolve to accommodate the changing reality of the world we live in, while at the same time being deeply rooted in tradition. As a tree that grows, but it's deeply rooted. From the other hand, we also have the constitutional architecture metaphor, which is seen as a more literal and conservative interpretation of the provisions of Canadian Constitution. Of course, depending on the approach, different balance can be struck and different means of persuasion may be used by attorneys at law before the courts of law when making reference to the Constitution. Another example, European Convention of Human Rights, for example, is seen as a living instrument. There's this living instrument doctrine, which of course proceeds for a dynamic interpretation of the European Convention of Human Rights to accommodate the new realities while preserving some of its core values. Some other examples are expanding the metaphorical concept of natural person and juridical person to non-humans, for example, to nature, right? Or even companies and so on, which has been seen as a matter of ecological urgency these days. And this approach has been or has already been used in some court cases in Germany, other EU countries, and worldwide as well, where the non-humans may invoke, for example, the European Convention on Human Rights even to protect the nature or company even, and so on and so forth. As for the legal reasoning, well, we already saw the example at the very beginning. This is an example actually of legal metaphors being used in legal reasoning, but there are some other studies as well. For example, metaphor used in the US Supreme Court decisions. Metaphor was studied in the context of custody cases where no rational basis as to why one parent should be given preference over another parent was presented, and the study revealed that the embedded knowledge and metaphor structures influence judicial decision-making, especially with reference to the traditional picture of what a family should look like. Metaphors applied by legal authors, another category I mentioned before. So this refers basically to legal academic texts written by legal historians, philosophers, doctrinalists, comparatists, especially in the area of comparative law. Metaphor is used frequently because it's an intrinsic part of any attempt to think comparatively. And here's one example of a culinary metaphor used in comparative law when discussing the division of the mixed legal systems that exist worldwide. So Orutsu divided these legal systems into 4 categories. You see the mixing bowl systems, salad bowl systems, salad plate systems, and puree systems, right? Yes, so from each end, basically from one end, so the grounds for this is the level of integration of different elements from different legal cultures or traditions. From one end, we have the mixing bowl systems where these different elements are very much evident and not fully integrated, whereas on the other side, we have the puree systems where these elements are fully integrated and it's impossible to recognize and make a distinction between them. So in this case, of course, metaphorizing is seen as an act of epistemic simplification, which is critical for any macro-comparative law attempts. Now, I hope I have convinced you a little bit that metaphors are very relevant for the legal discourse. And now let's move on to the approaches to the study of and translation of metaphors in the legal discourse. There have been many approaches and many methods. Of course, one of the most influential ones, and you're of course pretty much aware of it, is the conceptual metaphor theory by Lakoff and Johnson. We know metaphors to live by, the groundbreaking work and study. The inspiration for this lecture was also drawn on the title of the book, right, which is quite evident, in which, of course, they established that metaphor is not just a figure of speech, it's a fundamental mechanism of thought as well. We understand abstract concepts through mappings from more concrete or embodied experiences. And you know probably this basic structure of metaphors where the target domain is understood through the source domain. So, for example, in the metaphor, conceptual metaphor argument is a war. We can see that from the verbs, for example, used from which domains they're used. Like, he attacked my point, I defended my position, she won the debate. So you see, attack, defend, win. This is all the language from the domain of form. Or a law is a living organism metaphor, like the Constitution has evolved over time to adapt to the needs of society. Again, we can see the conceptualization behind it. Another important study within this field was the one formed by Lee, who basically tried to present an anatomy of a metaphor, which consists of 3 basic elements: the topic, the main subject of the metaphor; the vehicle, meaning the image that we use to transfer or explain that abstract meaning; and the grounds. So the grounds of similarity between the topic and the vehicle. The example that he uses is this: the past is a foreign country, where, of course, the topic is the past and how to explain it in it's an abstract concept. The vehicle that is used is this: it's a foreign country. And the grounds were that, of course, things are done differently, right? Both in the foreign countries, and that was the case also in the past. Here's one example to illustrate this within the context of law. To break the law, the example I mentioned before, of course, the law is here the topic, the vehicle is to break, and the metaphor is law can be broken just any object. Understanding this can facilitate learning process also when it comes to English language collocations, typical prepositions, patterns, which are used and so on and so forth, which I will mention later on. Now, how to identify metaphors in texts? Again, there are numerous approaches to this. One of the most influential approaches is the metaphor identification procedure developed by Pragmaja's group, which foresees the procedure composed of 4 main steps to identify metaphors in texts. Another approach is the Midifu approach, which is a more refined version of the previous approach, improving reliability and consistency of research among different studies. And within this approach, several categories were added: direct metaphors, indirect metaphors, implicit metaphors, and personification. And also, they introduced the use of metaphor-related words. So those words which signal or suggest that certain meaning is metaphorical. There has been an attempt recently, as you can see, this is the study fresh from the oven. It was published a few months ago by Diaz Dyson, who attempted to systematize these metaphorical markers into these categories you see here at graphemic level, phonemic level, lexical, semantic, syntactic, text structural, and pragmatic level. And this study was, interestingly enough, applied to even ancient Egyptian language to trace metaphorical meaning through the hieroglyphs and the metaphors which are signaled at the graphemic level by using so-called classifiers in ancient Egyptian. In ancient Egyptian, classifiers were usually located at the end of a word. And as you can see here, this is just one example for the word greedy, right? You can see a crocodile here, right? There's this, of course, sign as well, hieroglyph, which represents action or force, and the crocodile, those who pillage whatever they can get, those who steal whatever they can get. So it's to be as greedy as a crocodile, even though this is a simile, we can also see a metaphorical meaning. Angry also, interestingly enough, is labeled with the vehicle of crocodile. So it's very interesting to see how you can apply these theories even to understand ancient metaphors from ancient languages. Some other approaches include metaphorical pattern analysis by Stefanovic, who focused on recurring linguistic constructions that realizes and signals a conceptual metaphor in a corpus, and this was more suitable for a study on larger corpora. Then source domain lexeme that appear in target domain context, such as in this example, defend your argument. Then deliberate metaphor theory as well. They acknowledged that not all metaphors are equal, and I think we are aware of that. We were able to see that also from the previous examples. In some cases, the metaphor is used intentionally, deliberately. In some cases, not. It's just the fact of the language being metaphorical, or we're not even realizing that we're using a metaphor. It's some kind of mental lexicon conceptualization that we have, internal architecture, right, that we have. Of course, the identification of these metaphors is based on the Midifu approach, where a metaphor is considered to be deliberate, so used on purpose, is the speaker draws attention in a way to the use of metaphors. For example, it may be by a change of the tone. It may be by certain wordings. For example, let's consider this to be blah, blah, whatever, right? So there are certain signals that point to the deliberate use of metaphors. In writing, we can have a graphemic, as we had the example with hieroglyphs. So, for example, in English, it can be sometimes the use of quotation marks, right, italics, and some other way to signal the metaphorical use. A typology of metaphors is also important, especially for the studies in the field of translation. Welcome by Dickens and Newmark, who divided metaphors into lexicalized and non-lexicalized. Lexicalized can be divided into dead metaphors. We do not notice them, of course, anymore. We just use them, like foot of the mountain, or when we say case is closed, right? No one notices that this is a metaphor, right, anymore, but it is. Then stock or cliche metaphors, they are recognized, but they are used very, very frequently, such as food for thought or the scales of justice. And some recent metaphors, toxic relationship, information, highway, and so on. And non-lexicalized metaphors, which can be adapted and completely original. Like a man is a tree, this is not lexicalized, and this of course can be interpreted in many, many different ways, depending on what the author meant and had in mind when using this particular metaphor. And they can be adapted. He's skating on thin ice, he's snowboarding on lava, or this law often opens Pandora's box of litigation, and so on. And the original metaphors, his thoughts were fireworks that were trapped in a glass jar, law is a compass, not a cage, and so on and so forth. I'm constantly using my laptop because I'm used to. Okay, I apologize. When it comes to the approaches in the translation studies, of course, in translation studies, a systematic approach to the study of metaphors has been intensified as of the 1960s. But by and large, most of these studies you see here are based on the corpus of literary texts. So they were by and large focused on literary translation, right? When it comes to the legal translation studies, there's still a scarce number of studies available for this particular subject matter. There are some studies focusing on the legal discourse of EU white papers, for example, US Supreme Court opinions, challenges and impossibilities, translating metaphors, so on and so forth. And you can see some of the most recent, let's say, studies here in brackets. When it comes to the translation strategies, how to translate the metaphors, keeping it simple. Of course, there are many different, as you know, typologies and taxonomies of translation strategies. But in my research, I use the ones suggested by linguists, which is this. You can see a metaphor can be translated by image transfer when the metaphor in language A is translated with the same metaphor, right? Then image substitution, where metaphor is translated with metaphor, but we change the vehicle, another image, but it's still a metaphor. Then a reduction to sense, when the metaphor is translated by a paraphrase. Omission, when we do not translate the metaphors. Or compensation, when we do not have the metaphor in the source text, but we do translate whatever we had in the source text with a metaphor. So these are some of the most common strategies. Briefly, I will mention that although this is not the main topic of my talk today, this is from another study I did on the judgments of the European Court of Human Rights that showed that within these judgments, most of the metaphors are translated from English into Montenegrin, which is my language I work in, were translated with this strategy, image transfer, most of them. Then image substitution, reduction to sense, and omission rate is, as you can see, very, very low. And you have here more exact data. And most of the metaphors that I found in this particular corpus of judgments were transcultural, lexicalized, and dead metaphors. So not the ones we were able to see in the spoken discourse of a term at the beginning and sealed contexts. Okay, now this was the first part, okay, with a little bit of intro into the area. And now let's focus on legal metaphors in the judgments of the Court of Justice of the European Union, which I was asked to present today. Now, the research aims of this study I carried out were to determine and understand better the cognitive structure and general use of metaphors within this specific genre of judgments of the European Court of Justice, and to map the most frequently used conceptual metaphors for these 5 target domains. So this is what I focused on: law, court, rights, discrimination, and company. Okay? And to draw some implications for teaching legal English by introduction of metaphors and fostering metaphoric competence. Now, why is the Court of Justice of the European Union very interesting? Because, as you know, the working language of the court is French, obviously, but from all the 24 official languages of the EU, the documents can be used, right, depending on where the proceedings are taking place, in which country, before which court. This means that basically, to use another metaphor, it looks like a sand clock here, and all these different languages can come here into the court. They're translated into French, and then the case law is again translated into all these different languages. So if you're looking for a good corpus, an interesting corpus for the study, I think this could be a very interesting corpus for you to study. Although one disclaimer here, picture which I tried to make here was generated by using ChatGPT. I provided the prompt, but it seems that ChatGPT cannot understand how many languages we have and what are the language codes. So you can see all sorts of things, not 24. And I tried to correct it. Listen, you need to do this. This does not exist. But no, it doesn't work. Okay. Which is encouraging for us in a way also. Okay. This is the corpus which I used for my study. So the corpus was Eurolex judgments corpus. It's a multilingual corpus focusing on the judgments of the Court of Justice of the European Union. Overall, more than 10,000 documents from 1950s in 24 official languages are available, of course, in this corpus. So you can see the counts here in terms of tokens, words, sentences, and of course, I focus on the English section of that corpus. As I said, official judgments are drafted and deliberated in French, translated into English and other languages, but there are certain instructions for the translators working with the court. Lawyer linguists point out the importance of preserving the wording and language ambiguity, which means that some metaphors may be translated literally because of these instructions via image transfer. That was my initial assumption as well. The method which I use, so I used a sketch engine. I suppose most of you are familiar with sketch engine. I use the word sketch tool for querying the collocates that target the domain lemmas, because studies suggest that collocates are indicative of metaphoric behavior. I also mentioned before in some of the approaches, those words that signal the metaphoric use are to be narrowly watched. Then collocates output is organized into categories. Depending on the grammatical relations, is it verb object, subject verb, modifiers, and so on. And this is all based on the frequency list of collocates. And after that, I use concorder to evaluate, manually the collocates by random sampling, because we always need to check in the context the actual use or not to establish the metaphorical behavior. So I have just one example here. We know that typically the word requires an animate subject. So if we had this combination, law requires, this might be indicative of metaphoric behavior. Apart from this, I also use the visualize option within the sketch engine for distributional graphs for each collocate size circle corresponding to frequency and score of occurrence. And this is just an example how it looks like. So this is the visualization tool for the lemma law. These are verb collocates. You see verbs with law as subjects are here, given in green. And based on the corpus, of course, govern seems to be the most frequently used verb. Whereas in pink here, we have verbs with law as the object. Here we have top 10 collocations with frequencies and scores and so on and so forth that were then analyzed in the comparison. What are the results? So as for the law lemma, you have here the number of hits within the corpus, 0.243% of the whole corpus of the use, which is not that, important, but these are the most typical conceptualizations that I was able to harvest from this corpus. Law is most frequently conceptualized as a person. Like here, nonetheless, the provision of community law requires. So the law requires. Then the law is also conceptualized as a sacred place. As you can see here, community law, the fundamental principle of the community law is enshrined in Article 4, paragraph 1. To enshrine means to keep something in a shrine, in a holy place, like a sanctuary, to preserve, like holy scriptures or idols or whatever. A law is a source of light. That question must be examined in the light of the procedural law. It throws light on how to interpret and understand something. Then law is a structure. The basis of community law, it has basis, it has grounds on which it is built. Law is a tree, again, so we have branches of national law, right? And the law is a weapon also, right? Take the law into one's own hands, right? It's used as a weapon. And of course, this dates back to this ancient conceptualization of justice, you know, the lady justice with the sword and the skin. So there might be some connection in conceptualization. Now, these are the results for court. The court is most typically conceptualized as a person, right? So the general court examines, then as a body, in order to determine whether a body is a court. So the court is a body. Okay. Yeah, so these were the most frequently identified conceptualizations. Then this is the rights lemma.
Necesario.
Yes, we can see the results here. These are the most typical conceptualizations for the rights lemma. Rights are persons. Rights enjoy protection. Rights are plans. Rights stem from provisions. Rights are possessions. Rights acquired or in the process of being acquired, so they can be acquired. Rights are tools or instruments of agency, like concerning a right enabling something to happen, right? Discrimination. These are the results for discrimination. As you can see, we do not have a lot of verbs with discrimination as subject, but we do have a lot with discrimination as object. So these are the most typical conceptualizations. So discrimination is a structure. Discrimination on grounds of nationality. So it has its grounds on which it is built. That discrimination is an enemy. We need to combat discrimination, right? Discrimination is an illness. So suffer discrimination. Company lemma. Most typically, companies are conceptualized, perhaps not surprisingly, as persons, right? Like in both cases, the dividends received by the parent company or the company exercised the right, and so on and so on. Now, what could be some of the implications for teaching legal English? Having in mind the pervasiveness and importance of metaphors in languages for specific purposes, I believe that increasing metaphor awareness should be part of the syllabi, and this is something that is still not the case in a lot of LSD syllabi, right? And even in programs and textbooks and so on. Within the context of legal English, very randomly, or they're very scarce in legal English textbooks and syllabi. But some international organizations, such as these ones, which I interpret for, this is European Judicial Training Network. So it's a network at the EU level which organizes training sessions for prosecutors, judges, and so on in many countries throughout the EU. They have actually introduced legal metaphors modestly, but they're there in some of their training materials recently. So it can be found, for example, in this handbook, English for Human Rights in the EU. Okay? So there is this increased awareness about the importance of metaphorical competence also. Of course, metaphorical competence is very relevant because it promotes autonomous learning. Conceptual metaphors facilitate the learning of figurative idioms. Structured awareness of source domains helps towards the retention of unfamiliar idiomatic expressions. For example, I remember with my students when I explained the metaphor, so for some reason in Montenegro, it was very difficult because of the interference of the first language for students to learn collocations, typical collocations, and this is always a challenge, of course. But to break the law was something about very, very difficult for students to understand and to learn, acquire. But once we explained the metaphor behind it, it was much easier for them. It's okay. It's like an object that I can break. So to break the law, okay, and it works as a teaching tool. Of course, the metaphoric competence this is also very important, deepens understanding of semantic and pragmatic potential, along with intentional utilization of rhetorical skills, which are crucial for communicative competence in English, and of course not just English. And these are some pieces of research which you can have a look at that also testify to the importance of the use of metaphors in language teaching, not just in the legal domain. Also, within this context, I think it's important to stress the importance of corpus-based studies based on authentic language data. And when we say corpus-based, of course, this could be in reference to written language or spoken language, because there are also spoken corpora available or can be made, although it's more challenging to do that. There are several tasks, of course, that can be implemented while teaching legal English or other LSPs, such as group discussions, analysis debates, gap filling, matching and association exercises, listening, use of illustrations, and so on and so forth, to foster metaphoric competence. And you have here one example from one legal English textbook, where you have the teaching box here, you see, explaining in brief metaphors in law and in legal language. Of course, we are not working with linguists, so it has to be very brief, very concise, and very practical, right? And then some follow-up exercises, such as this one, discuss the metaphorical nature of phrases below. This is very good for communicative purposes and discussion with students, of course, maybe to compare with conceptualizations in their legal system and so on. Then to analyze some sentences and match the metaphors, to translate them, of course. Some listening exercises, of course, focusing on different metaphors, and so on and so forth. This is just really one example from one textbook. Okay, by way of conclusion, the study has shown, or suggests rather, that metaphors are a salient feature of the genre of the judgments of the European Court of Justice and also European Court of Human Rights. Most of the sampled metaphors are transcultural, lexicalized, and dead metaphors. So most of them are not even recognized or identified, right? The data also suggests that the analyzed conceptual legal metaphors are not incidental. They are not isolated mental conceptualizations, but rather part of a conceptual cluster forming a variety of relations. Of course, given the significance of understanding the profound cognitive meaning of the law for legal practitioners, there is an imperative, at least in my opinion, to incorporate metaphorical competencies to syllaba. I think we all realize how important this is for legal professionals, right, to be aware of these things. And I did mention there was also, as part of the Council of Europe's program, one training session organized. They usually organize their training sessions for attorneys and judges and prosecutors in many different formats, but they also have something that is called like lunch break webinars that last only for 1 hour, because all of them are very busy and they're usually organized online. And one of them was organized on the topic of legal metaphors also. So this competence, which is, I think, is still very frequently neglected, I think should be given more importance in the syllabi and curriculums. And of course, it should be based on authentic legal texts. And it can, of course, serve as a vehicle to promote critical thinking skills, which are essential for students' academic performance and occupations later. Okay, what I have presented here is, by and large, based on this study, published in the Revista Signos journal, Metaphors We Judge By, a corpus-based study of metaphor use in legal discourse. If you want to read more about it, you can read there. And another study, How Are Metaphors Rendered in Legal Translation, a corpus-based study of the European Court of Human Rights judgments. It's in the Journal of Specialized Translation. These are all, as you know, freely available online. They're open access. So if you're interested, you can read more. And thank you very much.
Thank you very much, Petar. We have moved from, at least I have moved from not knowing anything about metaphors in legal English to knowing a lot, or at least somehow. So thank you very much. Now it's time for questions. I will order for. We can have also questions in the chat if someone from.
I don't know if they can hear you. This is because the microphone is here with me, I think. Oh, there's another one. Okay, good.
So, who is going to break the ice? I can.
Yes,
Take it
yes,
by
I
myself.
can.
Or do you want it?
Yes, sure.
Yes.
Thank you very much.
Oh, yeah.
For me, it's been very, very interesting because I've always thought that metaphors are applied to terminology, not only to discourse, but to terminology. And you helped me to think about terms, legal terms or legal terminology, not in terms of terminology strict to nominal forms, etc., but in terms of UCA, discourse units. That is the PhD of Mona was about the conceptual units.
Okay.
So,
Great.
and my question is, well, for me, it's very, very interesting and a new thing to explore. But did you observe that I'm interested in the relation between the term and the language or general element, metaphorical element, well, that joins the term to break the law, for example.
Mm.
For me here, there is a concept that is law, and there is a noun or a verb, in the case like break, that is has a metaphorical compound.
Yeah.
That I can join to law. So the unit, the conceptual law, or discourse unit is break the law because there is a law and a break. And the metaphorical element is to break, not law. I don't know if I explained, but my question is, did you observe where is the relation between those elements? Are they very close? Are they not close? They can be in a part of a sentence, and so how they work, or how they, the general, the discursive element, the metaphorical element is close to the term or not?
Yeah, I haven't focused on that because my perspective was not from the perspective of terminology, right? It was more metaphorical pattern analysis, which involves all sorts of collocations that might suggest metaphorical use of for the target domain, not necessarily being a term, right? Although there is overlapping in some cases, obviously, but I wouldn't be able to provide some specific information because that was just not the focus of my study. Yeah.
Very interesting.
Without knowing about the legal discourse, from a terminological point of view, I would say that some terms are created by metaphor. So there is no distance. It's that the term is a metaphor, right? I would understand it like that.
Do you?
Yeah, I think so.
I'm not sure.
Yeah,
No, I'm not sure. It's my doubt. I don't know.
You say it generally.
yeah, not in
Not
In general, maybe.
Yeah, I don't know.
Yeah, in economy, for example, for increase the demand, no? Increase.
Yeah,
The only verb increase, it's a metaphorical verb.
Liquidity.
Yeah. Yes. Yeah. That's a good case.
It's a term and a liquidity.
Yes, but in legal language, it's
I'm not
difficult to
sure.
find terms created by
But liquidity will be
metaphor, the same term.
Right. I have my own intuition would go along with what Judith actually has mentioned. But I just don't have empirical data to support that. So my honest answer is I don't know because I haven't conducted research on that specific topic. So
I think in the case of law, it might be more difficult because there are it's more difficult to find equivalence because we have different systems in the economic. Easy because it's almost the same. We're talking about the same in liquidity here and US everywhere. But in legal terms, it's more difficult to find an equivalent.
Probably, but it also depends which legal genre are we talking about, because the situation drastically changes, right? Like, are we talking about legal academic texts in comparative law, right? Or are we talking about the judgments?
Yes, the judgment and the judgment.
Is it spoken or written? So I think it would be tricky to generalize it and apply to the whole legal domain, because initially it was thought that, legal domain was deprived in a way of figurative language and metaphors until we started really conducting research. And there were some legal scholars who even, as you were able to see, were strictly against that, right? You shouldn't use metaphors because of reason A, B, and C, right? But the reality, the linguistic reality, of course, is completely different from, so basically these are just some kind of speculations right now, but with no empirical evidence. Yes. But it could be perhaps a nice research topic to explore.
Not in terms, but in by the students.
I would like to go to the crocodile.
Egyptian? Okay. Wait.
No, I would like
Okay, yeah.
at the very beginning.
Yeah. I know what you mean. Okay, this one.
Okay.
The hieroglyphs.
Yes. My question is how, when translating, what's the best idea? Maintaining the metaphor or changing to more motivated metaphor in the other culture? And I went to the crocodile because, well, I don't know which is the image in our culture about crocodile, but for me, it's not pillage, it's that fake, because the crocodile is an animal that cries and it's not true. It's fake, no?
Yes.
So I have a different.
Compared to ancient Egyptians and Nile. And don't forget, this was the time when crocodiles lived in the lower Egypt, upper Egypt, before the dam was constructed in Aswan, which stops some of the animals going, in that part of Egypt.
So the idea is, when translating, maintaining the metaphor. Or during my land, that in the other culture you have perhaps the metaphor is not working and you have to change the metaphor for another metaphor. How do you?
Well, yeah. So these are. Let me just. I think these are the strategies. These are the strategies which are used for rendering metaphors. Metaphors are when we have a look at the broader picture in translation and interpretation. There's something that we call elements of culture, right? Which can be divided into extra-linguistic and intra-linguistic elements of culture. Metaphors are considered to be intra-linguistic elements of culture. And as is the case with any elements of culture, right? There's a lot of considerations we need to take into account when deciding which translation strategy to use. There is not one size fits all, of course. It depends on the type of text that we are translating. It depends on the scopus or intention of the text, right? It depends on the target audience, and so on and so forth, right? And of course, it depends on the congruence of two systems, lingua cultures, and if we are talking in the context of legal translation, two legal systems, right? If there is a gap or not, whether it will create confusions or not. You saw the instructions for the Court of Justice of the EU. The instructions are, to be as literal as possible to avoid possible ambiguities, right? Because of the multilingual context, right? So there isn't like a one answer to that question, because it really depends on a number of factors in that specific situation, right? So we couldn't say like strategy number one is the best one. Yeah,
What's easy, right?
it would make our life easier, but it's not like that.
This is little linguist.
It's little linguist.
The author is little linguist.
Linguist, yes.
Lita, the name is Lita.
Lindquist. Oh, the name.
She's a woman.
Yeah,
Yeah. I can't remember right now the name. Sorry.
because he gave a seminar here around 25 years ago.
Yeah, 5 years ago.
This is institutional. This is institutional memory.
I don't know if we have any questions from.
Yeah, there are two.
And Gloria, okay.
I en línia no pot fer algú.
Please, like.
So yeah, thank you for the presentation. As Julie said, I knew nothing about legal then, but after your presentation, I got to know more. And well, I was just thinking about how can the metaphors contribute to neology study? Because there are some kind of lexical units that are actually created in order to be a metaphor. So, for example, like break the law is like something that always exists, right? But there are some metaphors that maybe when you observe the corpus, you see some kind of metaphor, you will say, wow, this is something that I never saw before, and maybe it could be considered like the neological. So maybe the question is, when you analyze the corpus, maybe there are some kind of observations that.
Yes, absolutely. Metaphors and neology. This is very relevant, right? And you have some examples here of right of some innovation, right? But regarding your question and this specific corpus and this specific genre, I did not come across these examples for the target domains my research was focused on. And it seems, as I mentioned before, that written judgments. In most cases, the metaphors are lexicalized and they are dead in most cases, right? I'm not sure whether this would be the case if I were analyzing the spoken language.
Yeah, it could be like
For this, so judgments of courts have their own structure, which is predefined and so on, and the language seems to be more conservative in a way compared to the spoken language.
Thank
Nuria.
Thank you very much for the comment. Really interesting. I was wondering about the links of analogy to metaphor, in the sense that many of the lines, and I thought that in legal terms, analogy was working more than metaphor. For instance, some days ago I was discussing about the legislation of artificial intelligence.
Yes.
And then they were, I was discussing with lawyers, and they were telling, no, because artificial intelligence probably should be treated as slaves. As slaves in
slave, like okay.
In classical
right
law. Okay, and another one is saying, no, better like a pet. Yeah, okay. So, and then this word, I think, analogies.
Yeah.
What do you think? Are they analogies?
Yeah, of course. Yeah, I mean,
or they could become metaphors.
I think analogy is okay. Let me just show you here. Wait, oops, sorry. Let me just find the slide. Oh yeah. When we analyze metaphors, the third element is the grounds, and very frequently we have some kind of analogy there in the grounds of the images, the image which is, or the vehicle which is used for the metaphorical meaning. So there needs to be some kind of, in most cases, I guess, analogy, right, between these two concepts, the source domain and the target domain, which are being used, right?
But do you think, this is curiosity, maybe I don't know that answer. But do you think that something in a law would start as an analogy by becoming a metaphor for the opposite? So,
my guess would be yes. My guess would be yes.
Just to fix to agree on the ground and then. Exactly.
And this is very common in some branches of law, right? Like, as I mentioned, some examples of comparative law, right? In these fields. The AI thing, to be a pet, a slave, in some cases, also a tool, right?
Yeah.
These are metaphors.
My question is because in English, for instance, they can say it requires.
Yes.
Is less relevant if treated as a tool, that real as a personification, asking But in Spanish, for instance, with a distinction
Right.
around thing and person, this difference.
But what do you do in Catalan with law? I guess also in Catalan law can be personified, right? As a person. This seems to be a very
This would be
universal metaphor.
Thing,
So which pronoun would you use in that case? If I do,
No.
it's it.
No.
It's like
She.
Oh, it's she. Okay, that's very different. Yeah.
So I would say that ChatGPT, it requires, it can be analyzed.
Yes, yes.
But you still have the is and that. It's a metaphor, but it's not a personification.
And Montenegro, when I think about it, we use he. When you think about it, yes.
So it can be very good. I see as a person.
Law establishes.
Yeah.
The law establishes, she establishes
She
in
establishes,
Catalan. Okay, interesting. Does that have anything to do with the Lady Justice? You know, it's also a woman,
Yes.
Yes, perhaps it's.
like a Roman tradition. I don't know. Yeah, with a balance, with the scales of justice and the sword. Yeah, it's also a woman.
I have a question in relation to your question, because what is the really difference between analogy and metaphor? No, that metaphor is always an analogy. No?
Well, it's like as Professor just said, you know,
Analogy
is
But yeah, so the analogy is always in the grounds of the metaphors. That's one of the elements of
Yeah.
metaphors, right? Some kind of analogy with some degree of overlap, not all. And sometimes it, of course, depends which aspect of analogy we like to bring to the fore, right?
Yeah.
And which we would like to suppress or hide, you know. So this might result in using different metaphors, right? Because metaphors are, as we mentioned at the beginning, imperfect by their nature. They reveal some aspects but hide others, right? So.
but it's true that they can have very important legal implications.
Absolutely. Yeah.
So I'm thinking when if this law finally is set up, how it will be translated into different languages.
Yeah. Okay, interesting. Well, it's in Montenegro now. You got me thinking because in Montenegro it's a he, right? When we translate, yeah, it's a he. Yeah.
But do you have something like it and you choose it? Or
We do, but I would say I never use it with that reference. No, not as in English. No.
it's amazing.
And law is a he.
A law is a he.
And
In
here
Montenegro.
law is a she.
It's a she in Catalan. Then you see it's a it in English, right? I don't know in other languages. Do we have other languages here as well?
Okay, other languages.
And for an autonomous car, what would be your choice?
In Chinese.
For what?
An autonomous car.
Autonomous car? It's a he. Oh, you mean in Montenegrin or what? Sorry. So the pronoun? Oh, it's a he. It's a he. Yeah.
In Chinese, they say it's meat.
The Chinese objects are it.
It's it.
It's it. Yeah.
It's meat.
Okay.
Like the things that doesn't have life, it's a it.
In Australia,
How's that English?
We don't have all
German is also.
I mean, English, is it ChatGPT is it or he?
Yeah.
It. For you, is it?
Not he.
Thank you.
for us.
Very interesting.
Yeah.
And for translation, the importance in lexical restrictions, the translation of lexical restrictions, it's basic to know the metaphorical element in a combination, to translate in a
Yes.
good way.
And
Lexical
and to be aware.
It's very.
I think also in the legal context, it's very relevant to be aware of the nuances and potential repercussions, right? If the translation is not aware that depending on the metaphor that they choose, it can have completely different implications with the application and interpretation of the law in some cases, right? So I think this is very, very relevant. And here was actually an article, Why Metaphors Matter in AI Law and Policy. I mean, you might want to check.
Yeah, this will be important for all of us in the sense that
Yeah.
there are certain lobbies that try AI to have a juridical personality, and this is really dangerous.
Right. Yeah.
This is why they were comparing with the state.
Right.
The Roman civil law.
Would that mean if it's used for translation purposes, then if a mistake is made, they would be held accountable?
Yeah, that's the point. That if they are considered like slaves, even although they are
Okay, then the master in that case is accountable, right?
Yeah. But they are still accountable because they are
there is some agency in that. That's
so they are following instructions of the master.
Right.
But they are still
Yeah.
thinking.
It's a problematic metaphor.
Then they could refuse.
Yes, absolutely. Yeah.
Very interesting.
Yes. Okay. Well, thank you very much.
Thanks
very
for
much.
your